All right, why don't we go ahead and start? Thanks for coming, everybody. I'm Mike Klarman. I've been teaching here for about 9 years. I teach constitutional law, constitutional history, a seminar on the Warren Court. I'm really honored, flattered that so many of you would want to be here. I do have to question your judgment a little bit, though. I was flipping through the brochure, and I would have chosen several sessions over this myself. So I'm going to guess that you signed up for some of those other sessions and you were somehow frozen out. So I'm going to talk about, I wrote a book. It was published last year. It's about the making of the Constitution. I'm going to start just by explaining very quickly 3 different reasons why I thought this book was worth writing. As you probably know, there's a ton of stuff written about the making of the Constitution. Why do we need another book? And then I'm going to tell you 3 things, 3 kind of arguments from the book that I think cohere into a logical narrative. And then we'll have plenty of time for questions. I think what I'm going to do usually takes me about 45 minutes or so. So we'll have at least 40 minutes or so, I would think, for questions. OK, so 3 reasons why I thought the book was worth writing, even though there's already a tremendous amount, much of it very, very good, distinguished scholarship on the founding. Why do we need another book? First point. They're terrific books on particular parts of the founding. So every generation produces another good book on the Philadelphia Convention. There's Pauline Mayer's terrific book on ratification. Jack Rakove has written a distinguished book about the Articles of Confederation. There are books on the Bill of Rights. Nobody's actually written one volume from the beginning to the end. So starting with the flaws in the Articles of Confederation, carrying through to the conflict in the states over monetary and fiscal policy that played a very large role in the coming of the Constitution, through the Philadelphia Convention, then the struggle over ratification, the intellectual debate between Federalists and Anti-Federalists over whether the Constitution should be approved, and then finally the Bill of Rights, which, as you probably know, was added a couple of years later. So I thought there was a certain virtue in being able to go to one book and finding all of that. Second, it's possible now in a way that it wouldn't have been a couple decades ago to really go back to the original sources, which are pretty much gathered in one place, and they've actually been digitized. So there are about 30 volumes on a project called the Documentary History of Ratification of the Constitution. Each of those 30 volumes has something like 400 or 500 pages of documents. They've literally combed the world and found every newspaper article, every letter, every diary entry, anything that seemed relevant to the ratification of the Constitution. And that's in addition to the documentary collections of Madison's papers, Washington's papers, the documentary history of the First Congress. So it's possible now to, with a fair amount of ease, this stuff, as I said, has been digitized. You can literally sit in your bedroom with your computer and get access to all of it. It's possible to go back to the original sources and try to tell the story through the voice of the participants. And that's what I've tried to do. I think it adds a certain vibrancy to the story, but it also enables people to decide whether my interpretations seem convincing to them or not. I'm giving you the evidence. So I'm quoting Madison or Washington. I'm not saying take my word for it. This is how I interpret them. You can read their words and decide whether what I'm saying is persuasive. And then third and finally, I'm trying to put a sharper edge on an interpretation that's been around for a long time and that I basically agree with. That interpretation is the Constitution is best understood as a kind of conservative counter-revolution against forces of democracy and redistribution that were set in motion or accelerated by the Revolutionary War. Now, I don't say that's an uncontroversial interpretation, but it's an interpretation that's been around for a long time. Lots of people have subscribed to it. I basically agree with it. And as I said, I'm trying to put a sharper edge on it, and I'll explain as I move on to the other parts of my talk exactly what I mean by that. Okay, so those are the 3 reasons why I wrote the book. Now I'm going to tell you 3 things about the book, and I hope they cohere into kind of an intelligible narrative. Obviously, I'm not talking about everything in the book. The book is over 600 pages of text. For example, it doesn't actually come up very much in my talk, slavery, but there's a whole chapter in the book on slavery. I'm happy to answer questions about slavery, but for reasons that will become apparent, slavery actually is not an important part of the narrative that I'm telling. All right, if you're interested in the larger picture, though, you can't understand what happened in Philadelphia without understanding the conflict between states that had a lot of slaves and states that had very few slaves. All right, so 3 points that I'm going to make. I'm going to describe to you two ways. The first point has two subparts because we're lawyers and we love subparts. Two different points about ways in which the Constitution differed from what most Americans probably expected the Philadelphia Convention to do, and indeed probably wanted the Philadelphia Convention to do. Those are, first, the Constitution's more nationalizing, by which I mean simply shifting power from the state and local level to the national level. And the Constitution is more democracy-constraining or anti-populist. And I'm going to use those as synonyms, and I don't mean anything fancy. They're just trying to set up a national government that in various ways is removed from the direct influence of ordinary people. So that's the first point. Second point, I want to explain how the Philadelphia Convention managed to do these things that were different from what most people expected and probably wanted. And then third, and I think in a way most interestingly, how did they manage to get the country to approve something, part of which was addressed toward depriving ordinary people of influence over the national government? Why, in a fairly democratic ratifying process, would people approve a constitution, an important part of which was addressed toward limiting the influence of ordinary people on the national government? Now, when I say in a fairly democratic process, I immediately have to qualify that. From our perspective today, the process doesn't look very democratic. Women were not participating in politics. Most African Americans were enslaved. Even those who were free were often not allowed to participate in politics. Every state had property qualifications on the suffrage, meaning that poor people who didn't own any real estate weren't participating in politics. That doesn't sound very democratic from our perspective. But if you consider it from a different perspective, either the perspective of world history or the perspective of international practice at the time of the founding, this was the most democratic process the world had ever seen. Literally hundreds of thousands of Americans were voting for maybe 1,500 delegates who were then going to vote on whether the Constitution became the nation's governing document. The world had never seen anything like that. Not so democratic from our perspective, incredibly democratic from the perspective of world history and the democratic and the international context. Okay. So the first part then, I'm going to talk about the nationalizing features of the Constitution. One of those is the national government is given virtually unlimited taxing authority. Now, that doesn't sound, I think, very extraordinary to us today, but when you compare it to the relevant baseline, it actually is fairly extraordinary. Under the Articles of Confederation, which are what governed the country for the decade before the Constitution, Congress had no taxing power. Congress could requisition funds, which was basically a request for money from the states, but there was no coercive mechanism to enforce that. So the states either ponied up or not as they pleased, and often they didn't contribute their allocated requisitions. Under the Articles, there was a proposal to change that because people understood that you can't run an effective government without a coercive taxing power. So there was an amendment proposed under the Articles that would give Congress the authority to impose import duties. I won't get into this in detail, but import duties were seen as the easiest form of taxation at the time. We could talk more about that if people are interested. So there was a proposal to give Congress a very limited taxing authority to impose a 5% duty on goods coming into the country. That proposal was rejected because the Articles required unanimity for amendment, and there was never unanimity about any of the amendments proposed under the Articles, so the Articles were never successfully amended until the Philadelphia Convention just tore them up and started over again. So again, we're going from a system with no coercive taxing power, where there had been proposals to grant a limited power which were defeated, to a system with a virtually unlimited taxing power. Now, just one more point about that to illustrate. Congress is given the authority to impose direct taxes like taxes on land or taxes on people. Those were the most controversial form of taxes at the time, partly because they're regressive. A tax on people means poor people pay the same tax as wealthy people. Even more importantly, a tax on land, if you can't pay it, means you're going to be bankrupted and you're going to be thrown out off of your farm. A tax on imports, if you can't pay it, simply means you won't consume the goods that are being imported. And back then, most of the imported goods were luxury items. We weren't importing bread for people to eat. So Congress is being given unlimited authority to impose the most controversial forms of taxation, which enable you to throw somebody off of their land if they can't pay the tax. Second, Congress is given virtually unlimited authority with regard to the military. Congress is empowered to raise armies. Congress is empowered to create a navy. Congress is empowered to conscript state militias into federal service. Now, there are all sorts of limits you could impose on those powers, and the people who oppose the Constitution propose such limits. So you could say, of course, we'll give Congress the authority to create an army during wartime, but peacetime armies are very dangerous because they can be used to suppress political dissent as well as protect against invasion. So we're not going to allow armies during peacetime. Or we'll allow a small army during peacetime, but we want to limit it to 1,000 or 2,000 soldiers. Or standing armies are dangerous, so we should require that Congress vote by supermajorities if we're going to have such a standing army during peacetime. None of those restrictions are part of the Constitution. The Constitution gives Congress virtually unlimited authority over the military. Now again, contrast that with the Articles of Confederation, where Congress could only requisition troops from the states. That's a request. Like a requisition for funds, a requisition for troops doesn't come with any enforcement authority, so Congress makes the request and states may or may not comply with the request. Third, Constitution gives Congress unlimited authority to regulate interstate and foreign commerce. There was nothing like that under the Articles of Confederation. Fourth, Congress gets implied powers under the Constitution. There is a necessary and proper clause at the end of Article 1, Section 8. Article 1, Section 8 lists Congress's powers. Power to tax, power to regulate commerce, power to create postal roads. At the end of that is the necessary and proper clause. In addition to the enumerated powers, Congress can adopt laws necessary and proper to effectuating the other powers. That is an explicit grant of implied power. Contrast that with the Articles, where Congress was expressly limited to explicitly delegated powers. So under the Articles, there is an express denial of implied powers, and under the Constitution, there is an express authorization of implied powers. Fifth and finally, Constitution provides a mechanism for the enforcement of federal supremacy. Under the Articles, even if Congress was delegated an explicit power, such as the power to make treaties, Congress had no authority to actually enforce that against recalcitrant states. Now, that was seen as an obvious defect. Madison had a proposed solution that was very dear to his heart. Madison, who was more responsible, and we'll talk a little bit about this in a few minutes, Madison, who was more responsible for the Constitution than anybody else, he actually wanted to give the national government the authority to veto any legislation adopted by the states. Now, if you think about that, that's extraordinary. Even today, the national government has no general authority apart from its enumerated powers in which it can veto any state law whatsoever. Even this nationalist body of delegates thought that was going too far, and they came up as a replacement with a kind of three-part mechanism for federal supremacy. So those three parts are, first of all, the Supremacy Clause. Article 6 says explicitly, federal law, Constitution, statute, treaties are supreme over state law, and state judges are bound by that federal law, anything in state law to the contrary notwithstanding. A clear statement of federal supremacy that was not provided for under the Articles. Second, Constitution creates a United States Supreme Court, and it authorizes Congress to create lower federal courts. Under the Articles, there were no federal courts of general jurisdiction. So we've got an explicit supremacy clause, and we've got federal courts Supreme Court mandated, lower federal courts authorized but not mandated to enforce federal supremacy. The framers are anticipating that federal judges with lifetime tenure, protection against diminution of salary, they're going to be more faithful enforcers of federal law than state judges who are dependent on state legislatures for their salary, for their tenure in office, and might also just sympathize with state policy when it conflicts with federal policy. Third part, they actually come up with a specific substantive rule that they want the Constitution to implement to limit the states. That's Article 1, Section 10, which provides that states may not emit bills of credit, states may not make anything other than gold and silver legal tender, states may not impair the obligation of contract. Now that provision is responsive to something that was going on in the states in the mid-1780s and was one of the most important events that the Constitution was responding to. In the midst of a severe economic recession, which economic historians would rank, I think, second only to the Great Depression in the 1930s in terms of severity, states were trying to protect farmers from being bankrupted by issuing paper money that would allow them to monetize the wealth they had in their farms, but that they couldn't turn into actual cash to pay taxes. And states were passing debtor relief laws, trying to enable farmers to pay off their debts in installments, pay off their debts in goods rather than money. And the framers, people like Madison, Hamilton, Washington, they thought that those laws were irresponsible. They thought they were close to officially sanctioned theft. You were basically taking the property of creditors and redistributing it to debtors, and they wanted to stop that. So federal judges will enforce Article 1, Section 10. State judges are also bound by Article 1, Section 10 under the Supremacy Clause, and the Constitution will put a stop going forward to what they regard as irresponsible state efforts to provide easy money and fiscal relief to farmers in a severe economic downturn. A majority of states had adopted those laws in the mid-1780s. At the Philadelphia Convention, there was unanimity in the adoption of Article 1, Section 10. So I think that tells you right off the bat there has to be something a little unrepresentative of the Philadelphia Convention if the delegates are unanimously suppressing a form of legislation that a majority of states in only the 2 preceding years had been enacting. All right, so those are the nationalizing features of the Constitution. Now let me shift to the anti-populist or anti-democratic features. And the one I was just talking about is both, so it's a good bridge between the subtopics. Article 1, Section 10 both shifts power to the national level, and it's directed toward a populist form of legislation in the states. So in addition to Article 1, Section 10, what are the anti-populist features of the Constitution? First of all, very long terms in office. Now, as you know, House members serve 2 years, presidents serve 4 years, senators serve 6 years. That may not seem long to us, we're used to it. Under the state constitutions and under the Articles of Confederation, the norm was elections every year. In every state legislature but 3, the lower house was elected every year, and in 2 of those 3 exceptions, the lower house was elected every 6 months. Connecticut and New England, the lower house of the in Connecticut and Rhode Island, they had elections every 6 months for members of the lower house of the legislature. In a majority of states, governors served 1-year terms. In a majority of states, even the upper house of the legislature was elected to annual terms, and under the Articles of Confederation, representatives served only 1 year in office. So we're moving from 1 year to 2 years, 4 years, 6 years. There was nothing like that under the state constitutions, and it's worth noting that the delegates in Philadelphia almost went significantly further. So they provisionally agreed on 3-year terms for House members. Many of them, including Madison, would have favored 9-year terms for senators. 4 delegations, not individual delegates, 4 delegations favored lifetime tenure for the president. Alexander Hamilton favored lifetime tenure for the president and the Senate. He thought that was the only way you could adequately protect property rights and order against the democratic forces in the United States. So basically, lifetime tenure is the only way to protect property and secure order. Second, the framers adopted indirect elections. Second, in addition to lengthy terms in office, indirect elections. House members are directly elected. Senators, however, are selected by state legislatures, as you may know. That remained the case until the 17th Amendment adopted in 1913. Presidents were not elected directly either. They adopted a mechanism that distances the president in two ways from direct election. So under the Constitution, and this has never been changed in theory, but in practice it's evolved very differently from the way framers anticipated, the Constitution provides state legislatures choose the mechanism by which presidents are selected. Sorry, let me state that again. Article 2 says state legislatures choose the method by which presidential electors are selected. We do that by direct election, but many of the framers, maybe most of them, were not expecting that. They were expecting that state legislatures would just pick the electors. Then the electors get together in their own state, and they choose the president. Now, the way that's evolved in practice is they just vote for whichever candidate won the popular vote in their state. But the framers weren't anticipating that because they weren't anticipating political parties. So what they anticipated was a twofold remove from ordinary people. Ordinary people might pick their state legislators, but then the state legislatures might choose the electors, and then the electors would independently deliberate on who ought to be the president. So, for example, George Mason, who was a very important Virginia delegate at the convention, he's the author of the Virginia State Constitution and the Declaration of Rights. George Mason said at the convention, in response to a proposal that the people elect the president directly, he said, no, that's not a good idea, quote, it would be as unnatural to refer the choice of a proper character for chief magistrate to the people as it would be to refer a trial of colors to a blind man. Right? Think about that sometime. Right? Think about running for office on that platform. Right? The people can't possibly choose the president. They're too ill-informed and ignorant to be entrusted with such an important task. Third point about indirectness, even in the House, where people directly choose their representatives and they serve only 2 years in office, the framers came up with a variety of mechanisms to reduce direct populist influence. First, they created a tiny House of Representatives. In the first Congress, there would only be 65 representatives for the entire country. Now compare that to the lower house of the Massachusetts legislature, which had well over 300 delegates. 300 for just the Massachusetts lower house, 65 for the Congress that governs the entire country. What that meant was one member of the lower house of the Massachusetts legislature represented about 1,400 people back in 1787. Each congressional representative would represent 30 or 40,000 people. Now, if you're looking for a modern baseline, I think congressional representatives today represented about 700,000 people apiece. But 30 or 40,000 is more than 20 times what a Massachusetts representative would have in his constituency. Now, why did that matter? There are two reasons why they wanted a very small House. One is because they assumed that the larger the constituency, the more likely the quote-unquote better sort of the community would be elected to office. The well-born, fairly wealthy, well-educated gentry, they're more likely to be the ones elected to office in a large physical constituency because they're going to be the ones with the larger reputation. Second, in an era of very primitive transportation and communication, they were assuming quite plausibly that the larger the physical constituency, the more remote the connection between voters and their representatives would be, thereby enabling representatives some slack in their relationship, essentially allowing them, in Madison's words, to refine and enlarge the views of their constituents. A critic of Madison might say, ignore the views of their constituents. Okay, so in the House, very large constituencies in order to enable the better sort who will be more remotely connected to their constituents. Second, this is not widely known. The Constitution actually authorizes Congress to tell states that they have to elect their congressional representatives at large. What that means is, to give a specific example, Virginia had 10 representatives in the first House. Virginia was by far the largest, wealthiest, most powerful state. 10 of the first 65 congressmen come from Virginia. Article 1 of the Constitution says state legislatures get the first crack at specifying the time, place, and manner of federal elections, but Congress can then revise those regulations. Now, what the framers were clearly anticipating is Congress could say to Virginia, you have to elect all 10 of your representatives at large. What does that mean? Well, you would give all Virginia voters 10 votes and give them a list of candidates, and the candidates getting the most votes would then represent the entire state. All Virginians would elect 10 representatives who did not represent districted communities, they represented the entire state. That's creating an even more gigantic constituency, which is even more likely to elect the better sort to office and give them more room for maneuver in disregarding the views of their constituents. And then the last point on this dimension, the Constitution omits 3 mechanisms that you might call democracy or populism enhancing mechanisms. So the Constitution does not provide for instruction, it does not provide for recall, and it does not provide for mandatory rotation in office. Many state constitutions did. The Articles of Confederation provided for 2 of the 3. Let me just explain briefly what these are that the Constitution leaves out. Instruction means pretty much what it sounds like. Constituents could instruct their representative on how to vote on a substantive issue. So a Massachusetts town meeting could tell their representative in the Massachusetts House of Representatives, they could tell, the town meeting could say, we want you to vote against a tax increase, we want you to vote in favor of declaring independence from Great Britain, and if the representative didn't do as instructed, they would be morally bound to resign. Constitution does away with that. Recall means even during your elected term in office, you can be recalled by your constituents. So under the Articles of Confederation, congressmen were elected by state legislatures for annual one-year terms in office, but they could be recalled at any point if the state legislature didn't like the way they were behaving. And finally, mandatory rotation is just like it sounds. It's term limits. It's a way of preventing office holders from getting entrenched in office. Constitution leaves that out. Lifetime tenure for Article 3 judges, but also no limit on the ability of a senator or a president to be elected ad infinitum. Right? We changed that with the presidency in the 1950s. We amended the Constitution after FDR had served 4 terms. But under the original Constitution, no term limits, mandatory rotation. Critics of the Constitution said presidents will simply be elected for life. All right. The purpose of leaving those democracy-enhancing provisions out and the purpose of putting in the anti-populist provisions was quite clear. It was twofold. One is they wanted to prevent the federal government from ever adopting the sort of populist legislation that the states had been adopting in the mid-1780s. And second, they wanted the federal government to constrain the states from adopting similar legislation going forward. All right, so that's the first part of my talk. Now I want to talk about how the Philadelphia Convention managed to do these things, which I've suggested to you were slightly unrepresentative of what the country was expecting or perhaps desiring. One leading contemporary critic of the Constitution, these people were called Anti-Federalists at the time, and that's what historians call them as well. One leading Anti-Federalist observed, and I think this is accurate, quote, the democratic and aristocratic parts of the community were disproportionately represented in Philadelphia. think that's right. And the question is why. And I'm going to offer you several discrete points that I hope in combination might amount to an explanation. But I also want to say this is where I'm trying to put a sharper edge on this view that's been around for a long time. Lots of people previously have embraced the view Constitution's kind of a conservative counter-revolution by the more aristocratic forces trying to stem the tide of democracy and demands for redistribution. But the question that historians have not focused on is how did they get the Philadelphia Convention to do their work, and then how did they convince the country to approve it? And that's where I hope I've added something to that explanation that's been around for a while. Okay, so several discrete points. I acknowledge openly this is speculation. I'm doing the best I can to explain what seems like a somewhat puzzling phenomenon. First, we have to ask, how did state legislatures choose who would represent them in Philadelphia? Rhode Island chose not to be represented at all. Rhode Island did not go to Philadelphia. If people are curious, we can talk about that in question and answer. The other 12 states did go. All of them but one legislatures chose the delegates. South Carolina, the governor chose the delegates. Everywhere else, state legislatures chose. Who did they choose? Well, in many states, like Virginia, they just chose the most famous, eminent characters in the state. So Virginia sends to the Philadelphia Convention who? They nominate George Washington, Patrick Henry, George Mason, Edmund Randolph, the governor, James Madison, the most eminent citizens. Now you have to ask yourself, okay, how does somebody become one of the most eminent citizens? And the answer is probably some combination of they have a national reputation because they've served the nation. Maybe in the military, maybe they were members of the Revolutionary Army, maybe they served in the Confederation Congress, and they're probably wealthy, large landowners. And that's true about most of the delegates of the Philadelphia Convention. Now, having a national reputation is highly correlated with being kind of nationalist in your outlook. If you served in the Confederation Congress, you've gotten adjusted to the idea of thinking in terms of the nation's interests rather than local parochial interests. Serving in the Confederation Army is profoundly nationalizing for two reasons. One is you're serving in an army that's trying to create a nation, and the second is the states actually were seen by many soldiers as substantial impediments to success in the Revolutionary War. So biographers of George Washington, John Marshall, who was also a soldier, the great Chief Justice later, they've actually traced their nationalism back to their service in the Revolutionary Army when they became very resentful of states that they saw as obstructive to success in the Revolutionary War. Being a large, wealthy landowner is correlated with having anti-populist views. Most people who are fairly wealthy did not think much of populist efforts to redistribute wealth from creditors to debtors. So simply in the pool of people who you would send to Philadelphia, if you were thinking in terms of your most eminent citizens, there's probably something of a bias in favor of nationalism and anti-populism. Second, the opponents of the nationalizing anti-populist agenda of the convention, they actually had no reason to mobilize in advance in opposition because they had no way of knowing what the Philadelphia Convention was going to do. And the reason for that is the agenda mostly existed in the mind of one man, James Madison. That's not because Madison was the most eminent person in Philadelphia. He certainly was not. George Washington was there. He was the most famous and beloved American citizen, perhaps of all time, by contemporary Americans. Benjamin Franklin might have been the most famous person in the world in 1787. He was there. Madison is not a formidable speaker. Often people in his presence can't hear what he's saying. He's not a commanding physical presence like George Washington. He's actually pretty short. He's often ill. Madison is the foremost player in Philadelphia for one reason only. He is the best prepared person in the room. He spent months before, and he's brilliant. That helps too. Madison spent months before the Philadelphia Convention studying the history of conventions. He looked at the articles, he looked at the state constitutions, he diagnosed their flaws, and he came up with a remedial plan. He then organized the Virginians to go early to Philadelphia where they could orchestrate among themselves the details of that plan. They coordinated with the Pennsylvanians, Those are the two largest states, Virginia and Pennsylvania. The Pennsylvanians were already in Philadelphia because conveniently all of the Pennsylvania delegates actually lived in Philadelphia. And those two largest delegations coordinated around a plan that was known as the Virginia Plan. It was introduced on day one of the convention. It became the working blueprint of the convention. And even though lots of things Madison cared about, he lost on, where you begin influences where you end up. And they started on day one with a fairly nationalizing, anti-populist set of resolutions because of Madison's influence. Third, some delegates who were appointed to the convention, about 8 or 10 of them, turned down their appointments and then became leading opponents of the Constitution, leading anti-federalists. Patrick Henry of Virginia, Richard Henry Lee of Virginia, Samuel Chase of Maryland. Those were some of the leading delegates who'd been appointed but chose not to go to the Philadelphia Convention. Now, why did they choose not to go? It's hard to know for sure. Some of these people offered reasons and some of them didn't. Even the reasons they offered, sometimes we might or might not want to credit those reasons. If somebody said, I'm not going to Philadelphia because I'm ill, maybe they were ill or maybe it's a convenient excuse. Patrick Henry might have said that his resources at the time wouldn't permit him to go. Maybe that's true. Patrick Henry's political opponents speculated he had other reasons for not going. I'm simply going to toss out another possibility, which I admit is speculative, and this is a very small sample size, so it's dangerous to try to generalize. But it seems to me plausible that some of these people who were appointed to Philadelphia chose not to go and then became leading anti-federalists. Maybe the reason why they didn't go is because they assumed what the convention was going to do was a mildly nationalizing enterprise. Give Congress a limited taxing power, give Congress a limited military power. They didn't dream that what the convention was going to do was a radical reform initiative. And if they'd known that, they might have gone to fight against it. But given what they thought would happen, that was something that didn't really interest them. It didn't concern them, but it also didn't interest them. Maybe that's why people like Henry didn't go. Fourth, there was a decision by some delegates who did go and who opposed the nationalizing and democracy-constraining enterprise to leave early. So this is Yates and Lansing of New York. When they left early, they essentially deprived New York of its vote. So Alexander Hamilton, who was the most extreme nationalist of the bunch, he actually followed them out of Philadelphia soon thereafter because with New York only having one delegate, it was no longer entitled to a vote. This is also Luther Martin of Maryland. Now, when you walk out of something that you disagree with and that you deny is legitimate, you're always making a calculated risk. Walking away from it is to suggest it's illegitimate so you won't be bound by its outcome. But by walking away from it, you also enhance the chances that it's going to move in the direction that you oppose. Right? This happens all the time in the world today. This is the Kenyan opposition today deciding whether to participate in the repeat election. They think it's going to be fixed, so they've decided not to participate. If they participated, they might actually win. It's a difficult choice to make. You can understand why people would decide one way or the other. I think Yates and Lansing made a mistake. They thought that what the convention was doing was illegitimate, and they wanted to delegitimize it. By walking away, they ensured that the convention would render an even more nationalizing and democracy-constraining document. 2 more points on this dimension. The delegates made a critical decision on day one to close the doors of the Philadelphia Convention. Now, they had some good reasons for doing so. Madison said later, and this is plausibly right, they wouldn't have produced any constitution if they hadn't closed the doors. Closing the doors means essentially there aren't going to be newspaper reporters there publicizing what was said. By closing the doors, I think they had 2 important impacts. One is they liberated the delegates to make the most extreme statements in favor of a nationalizing, democracy-constraining constitution. They would have paid a political price for those statements had there been newspaper reporters writing them down and then publishing them in their newspapers. Second of all, they prevented the Anti-Federalists from getting an additional 4 months to organize in opposition. The convention started around May 25th. It ended on September 17th. What was happening in Philadelphia was a closely guarded secret. If the Anti-Federalists had had those 4 months to start organizing opposition, it would have been very helpful to them. This is an era of very primitive transportation and communication, and as we're going to see in a few minutes, the Anti-Federalists were especially disadvantaged in their efforts to organize opposition. So it would have been very convenient for them to know what was going on in Philadelphia. Sixth and finally, the delegates made a momentous choice. They decided that they would go for broke. Madison and Washington had been exchanging correspondence before the convention, and they were pleasantly surprised to discover that they agreed that what should happen in Philadelphia should be radical reform, not what they called temporizing expedients. Randolph, the governor of Virginia, who introduced the Virginia Plan, because on day one, Washington becomes unanimously the president of the convention, which leaves Randolph as the senior member of the Virginia delegation. So Randolph introduces the Virginia Plan, which was mostly attributable to Madison. Here's Madison recording what Randolph said on that opening day, and Madison's notes are our main but not only source on what was said in Philadelphia. Quote, he, meaning Randolph, would not, as far as depended on him, leave anything that seemed necessary undone. The present moment is favorable and is probably the last that will offer. Hamilton said similar things. Madison said similar things. Rufus King from Massachusetts, another big nationalist, said similar things. Their calculation was the system is broke. We need to fix it. Fixing it requires radical reform, not incremental reform. This may be the last chance we have to accomplish that. Let's not waste our opportunity. Okay. Third part of the talk, how they get this thing ratified that was so different from what people anticipated and perhaps desired. First point I want to make is not an explanation, it's a point of emphasis. They barely managed to get it approved. One real problem, a large problem for historians, is that you're telling a story but you already know what the outcome is, and it's very tempting to try to explain the outcome going backwards and making it seem inevitable, especially something as important to the American consciousness even today as the Constitution. It's hard for us to believe, this is true about the Civil War as well, the best histories of the Civil War emphasize the contingency of the outcome. The Union did not have to survive the Civil War. There are at least 3 or 4 battles. If they had turned out differently, the South might very well have managed to get Northerners to give up on the war, which would have been a victory for the South. Same thing's true about the Constitution. We shouldn't delude ourselves into thinking it had to be adopted, and what would have happened had it not been adopted is actually a fascinating counterfactual that we can speculate, but sure that we don't know the answer to. The Constitution was a very closely fought affair. North Carolina initially rejected ratification. Rhode Island initially rejected ratification. The New Hampshire Convention was set to reject ratification, but the Federalists who had arrived early and set the procedural rules actually managed deftly to adjourn the convention to have it reassembled months later. Otherwise, New Hampshire probably would have rejected. And in 3 of the 5 largest states, the vote was so close that it's easy to imagine it coming out the other way. So in Virginia, the vote was 89 to 79 in favor. In New York, it was 30 to 27 in favor. And in Massachusetts, it was 187 to 168 in favor. Very narrow margins of approval. Easy to imagine the Constitution meeting a different fate in those states. As I said, those are 3 of the 5 largest states. It's easy to imagine if 1 or 2 of those large states rejected ratification that the Union would have failed even if 9 states had ratified, which is what Article 7 of the Constitution provides will be sufficient for the Constitution to go into effect. Even if you had 9 states, if you didn't have Virginia and Massachusetts, 2 of the 3 largest states, it's a little hard to imagine the Union being successful. Okay, so what are the explanations for why the country approved the Constitution? I'm going to talk about three different sorts of explanations. The main one has to do with the Federalist built-in advantages. Then I'm going to say a word about anti-Federalist miscalculations. Then I'm going to make a final point about how the Federalists deftly prevented the country from having a choice on intermediate solutions, and then I'll be done. I'll just wrap up quickly. So Federalist advantages. Now, I don't mean this as some sort of conspiracy theory. These things just happen to be the case, or sometimes the Federalists actually made their own luck. But it's not that there was some grand conspiracy that ensured that the Constitution would be ratified against the wishes of the American people. First point is malapportionment. This was especially true in South Carolina, but it was also true enough in Rhode Island and New York that it might have made the difference. Malapportionment meaning simply you did not have one person, one vote in the ratifying conventions. So let me explain with regard to South Carolina where the malapportionment was extreme. Malapportionment is a result of population moving over time, but political power not being redistributed to reflect that population shift. In the 20th century, that was mostly movement from rural areas to cities. In the late 18th century, it was mostly movement from the Atlantic seaboard to the western frontier. In South Carolina, the malapportionment was extreme. So in South Carolina, 50% of the population is enslaved. They're not voting, obviously. And of those whites who otherwise might be eligible to participate based on their race, probably about 40% of them don't own enough property. But all that's to one side. That's not relevant to what I'm talking about. Of those who are allowed to participate, 20% live along the Atlantic seaboard. They elect 60% of the delegates at the Charleston ratifying convention. Now that matters because support for the Constitution is highly correlated with region. As you move from east to west, you're going to get rapidly diminishing support for the Constitution. So the 20% that elect 60% are the ones most likely to be supportive of the Constitution. Historians agree that if South Carolina had had a referendum on the Constitution, it probably would have rejected it, but the ratifying convention approved it by a margin of 2-1. That's how extreme the malapportionment was. Second, and maybe this is an even more important point, the press overwhelmingly supported ratification. In the 1780s, 90% or more of the population lived outside of cities, but for obvious economic reasons, newspapers were published almost exclusively within cities. Now, the two most important economic drivers of newspapers, and I think this is as true today as it was 225 years ago, were advertisers and subscribers. Advertisers in newspapers and subscribers to newspapers were among the groups most likely to support the Constitution. They would actually threaten boycotts against newspaper editors who dared to publish both sides on the ratifying debate. So anti-Federalists in some states, not all states, actually had a hard time of getting their essays published in the newspapers. In the words of one of these anti-Federalists, Adnis Burke of South Carolina, quote, "The whole weight and influence of the press was on the side of the Constitution." There are about 90 newspapers in the country in 1787-88. Of those 90, only 12 published any significant amount of anti-Federalist literature. Third point, several of the ratifying conventions took place in coastal cities. In coastal cities, support for the Constitution was almost universal. Now that's across class lines. It's not only the bankers and lawyers and merchants, it's also the carpenters and blacksmiths and innkeepers. In a city like New York, when they're voting for delegates to the Poughkeepsie ratifying convention, 19 out of every 20 voters votes for a Federalist candidate. That's how lopsided opinion was in the cities in favor of the Constitution. This has an effect both inside and outside of the ratifying conventions. All of the conventions were open to the public. Unlike the Philadelphia Convention was closed. That means there's going to be crowds in the galleries. In Boston, 1,000 people line up on a cold January day because they want to see these debates, which are the best entertainment in town. They actually had to move the Boston convention twice to find the largest church in town that could accommodate the 1,000 people who wanted to get in to see it. Now, the crowds who are occupying the crowds in the galleries, they're going to be overwhelmingly Federalist if you're in a city. So the Massachusetts convention is in Boston. It's not in Worcester. The South Carolina convention is in Charleston, a coastal city, not in Columbia, which is in the middle of the state, and it's where the state capital had just voted to be relocated to. The Pennsylvania convention is in Philadelphia. It's not in Lancaster or York. So you're going to have eastern cities in many states that are overwhelmingly pro-Constitution. The Federalist galleries are going to, the spectators in the galleries, if an anti-Federalist gets up to speak, they boo, they hiss, they spit, they stomp their feet, they're rude. Anti-Federalists can't even get their speeches made without being insulted and hissed into silence. Outside of the conventions, it also has an effect. So when they adjourn from their daily convention in Charleston, South Carolina, they go to open houses that are being held by the Charleston planner elite. And in those open houses, you can be pretty sure they're having whispered into their ears only pro-Constitution sentiments. Fourth, another important Federalist advantage is simply that even if the Federalists and Anti-Federalists have roughly equal numbers of supporters, the Federalists have an advantage simply in organizing those supporters. That's because Federalist supporters tend to be in cities, and they tend to be along the eastern seaboard. And again, this is an era of very rudimentary transportation and communication. Anti-Federalists tend to be along the western frontier or in backwoods regions throughout the state that are only remotely tied to commercial networks. Even if there are equal numbers of supporters and opponents, the Federalists will have an organizing advantage just based on the geographic distribution of support and opposition. Fifth point, the better sort, the well-educated, elite, well-born, often quite affluent members of society, they overwhelmingly support ratification everywhere but in Virginia. In Virginia, the elite's actually pretty evenly divided, but in other states, the lawyers, the doctors, the clergymen, the bankers, the merchants, they tend to overwhelmingly support ratification. That's going to be a disadvantage at conventions if there are genuinely open minds subject to influence. And at some conventions, people seem not really open to influence, but at others, it's quite clear that lots of delegates change their minds. Backwoods farmers were not able to quote Cicero in the original Latin. They're often unwilling to stand up and do battle against better educated, more socially elevated opponents. They're intimidated by speaking against their social superiors. Thus, for example, at the Massachusetts ratifying convention, an important anti-federalist named Amos Singletary complains, and I'm going to give you the quote, but I want to say before I do, I just want to preface it. Amos Singletary is speaking in a voice dripping with sarcasm. Amos Singletary does not think that the educated lawyers and doctors are better than him. He's actually very articulate, very learned, but he thinks they think they're better than him. So this is with a voice dripping with sarcasm. He complained of, quote, these lawyers and men of learning and moneyed men that talk so finely and gloss over matters so smoothly to make us poor illiterate people swallow down the pill. Amos Singletary is not illiterate. Probably none of the anti-federalist delegates at the convention are illiterate. Estimates are that 90% of adult white men in Massachusetts could read and write, if for no other reason than they had to be able to read their Bible. Amos Singletary is expressing a common populist denunciation of the elites. That was pervasive at the Massachusetts convention. They did so much denouncing of lawyers that at one point, one of the anti-federalists had to stand up and put in a good word for lawyers. Right? Some of my best friends are lawyers. Sixth and finally, the genius of Article 7 was a huge Federalist advantage. This is Article 7 of the Constitution, so this is an advantage they created for themselves. Article 7 provides 9 states can ratify and put the Constitution into operation. Those 9 states can only bind themselves. So you might ask yourself, well, how in the end is that different from the unanimity requirement of the Articles if in the end no state can bind any other? It turns out it's massively different, and the framers understood that. Once 9 states have ratified, the other 4, in theory, are free to join or not. But notice they are no longer facing the same choice set. The question now is not, do you prefer the Constitution to the Articles, but rather, would you prefer to be in a new form of government or be an outsider to it? In practice, if you do not join the Union once 9 states have ratified, you will be denied representation in the first Congress. Well, they will be deciding very important things like where's the national capital going to be located, which is worth a lot of money to whichever city is the lucky recipient of the capital. You will be denied federal military protection. If you're about to have a war against Native American tribes, as they are in Georgia, the federal military is not going to protect you if you're not part of the Union. And you may be subjected to foreign trade discrimination. If you're Rhode Island and you're dilly-dallying over ratifying the Constitution, Congress will pass a law, which it did, threatening to treat Rhode Island as a foreign country and impose tariff barriers on its goods. So in practice, once 9 states have ratified, the other 4 states have very strong incentives to fall in line. All right, those are the Federalist Advantage. I said I'd mention Anti-Federalist miscalculation. There's one I want to point to. In especially New York and Virginia, I think the Anti-Federalists in the legislature made an understandable miscalculation. Understandable, but it turned out to have deleterious consequences for their cause. Virginia and New York hold late conventions. They meet in June of 1788. That's 9 months after the Philadelphia Convention adjourned. Some states were already holding conventions in November, just 2 months after the Philadelphia Convention adjourned. Why are New York and Massachusetts going so late? Anti-Federalists in the legislature agreed, I keep saying Massachusetts, Virginia and New York. Why did Anti-Federalists in those legislatures go so late? I think probably they've calculated they need more time to organize their supporters. Maybe they thought their states would be more influential if they went late in the process after earlier states had disagreed. They could swoop in and provide a solution, but they actually simply made themselves irrelevant. By the time Virginia and New York ratified, 9 states had approved the Constitution. Now, that's a little bit of an oversimplification because New Hampshire voted and Virginia didn't discover it until afterwards. But Virginia knew that 8 states had ratified, and they knew New Hampshire was on the verge of ratifying before Virginia approved. And then by the time New York ratified, they knew that Virginia and New Hampshire had ratified. So New Yorkers knew that they were going to be the 11th state to ratify, and that absolutely determined the outcome of the New York Convention. If Virginia and New York had gone earlier, there is a very high probability that they either would have rejected ratification or they would have ratified only on the condition that amendments be adopted before the Constitution went into effect. And if New York and Virginia had gone earlier and reached those other outcomes, that would have disrupted the momentum in favor of ratification that had been building as state after state approved. All right, the last important point to note, this is something that I learned while working on the book. This is not something I had learned from reading secondary literature before I started on the project. The Federalists were very astute at denying the country an intermediate choice. And it turns out that's probably what most Americans would have wanted. Most Americans would have agreed the Articles are flawed and need to be redressed. But most Americans, or at least a great many Americans, thought the Constitution was a more radical reform than they were comfortable with. So what most people probably would have wanted was an intermediate solution. The Federalists desperately sought to keep that solution off the table. The way that solution would have gotten onto the table was by one of two procedural mechanisms. Either a state insisting that they would only ratify on the condition that amendments first be proposed and approved. I'll call that antecedent amendments, ratification conditioned on antecedent amendments. Or the second procedural path was a second convention. Anti-Federalists made pretty good arguments for those procedural routes. Patrick Henry in the Virginia Convention said, what sort of fool would you have to be to enter into a contract with another party where that party later gets to specify different terms? That's essentially what the states were being asked to do. Approve the Constitution with a vague preference, a vague statement, a vague promise that down the road there may be amendments offered. And Henry says you have to be a lunatic to do that. Tell me what the amendments are now, and let's actually adopt the amendments, and then I'll ratify. The argument for a second convention was we just had a national debate on something that was sprung on the country with no advance notice. It was very different from what people had been led to believe would happen in Philadelphia. They closed the doors of Philadelphia. Now we've had months to deliberate on it. We've identified flaws. We've proposed amendments. Now let's elect delegates to a second convention where we can produce something closer to what most Americans would be comfortable with. The Federalists responded both by making practical arguments and legal arguments as to why neither of those procedural methods were actually acceptable. But the real reason why the Federalists opposed is because they didn't want the intermediate solutions. They liked the Constitution as they had drafted it, and that's what they wanted the country to receive. So in this regard, consider finally a proposal by Randolph that he made in a letter to Madison before the convention. Madison is tossing off his ideas to Randolph, and Randolph says in response, whatever we do in Philadelphia, we should submit it to the country in a kind of detachable form. Let people approve what they like and disapprove what they don't like. Madison's response was horror. The idea that ordinary people could possibly have informed views on the Constitution was foreign to Madison. This is what he said in a letter to Jefferson later in 1787. In Virginia, quote, where the mass of people have been so accustomed to be guided by their rulers on all new and intricate questions, the matter of whether to ratify the Constitution certainly surpasses the judgment of the greater part of them. Right, another good platform to run for office on sometime. All right, so to sum up, the Constitution is much more nationalist, much more anti-populist than the framers, and that most of the Americans probably wanted, certainly than they anticipated. Framers took advantage of some circumstances that were advantageous. They took advantage of the element of surprise. They took advantage of some miscalculations by their adversaries. Whether you agree with what they did in Philadelphia, whether you think it's legitimate, and the Anti-Federalists raise legitimacy objections all the time, I think you have to stand back and admire what they managed to execute. It really is a kind of coup against public opinion. So that's what I wanted to say, and I'm happy to take any and all questions. Thank you.